Today's date is Tuesday, October 11th, and you are the first of two video arguments that we're going to be hearing today. As you can see, the panel is Judge Hensel, Judge Callahan, and myself. I'll be presiding here today and keeping track of time. So Attorney Hall, you let me know how much time you want to reserve, and I'll let you know as you get close to that time. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. This is a criminal case, so we do not refer to victims or children by name. Just use initials or somehow some other way to reference them. We have read the briefs and we are prepared to proceed. So let me start by asking you how much time you would like to reserve, Attorney Hall.
5 minutes, Your Honor, I'd like to reserve. Thank you.
All right. And again, I'll let you know as you get close, or if you're answering a question and going beyond it, I'll let you know what you have left. All right, with that, you can proceed. Thanks.
Your Honor, good morning. Good morning, Attorney Philbin. This is Attorney Eric Hall representing the appellant Brian Wilk Jr. Excuse me. This case, the appellant was charged and convicted of aggravated menacing, misdemeanor of the first degree. The facts, I think, are important in this case. This happened at the end of a holiday weekend in May. It was at nighttime. There was a large crowd had assembled outside the appellant's house. They were, my understanding, they were noisy. They were crowding into the street in front of his house. There were some vehicles there, a lot of vehicles. And then there were some individuals, excuse me again, who were crossing and coming onto the appellant's property. The appellant was concerned, okay, that's probably an understatement. He possessed or owned an air pistol. It's a non-lethal type of instrument. It looks like a firearm, okay? I mean, it resembles a firearm. And he had that air pistol holstered, okay? When he went outside to basically to find out what was going on and ask these people to leave, there was a confrontation outside, an argument, I believe. The appellant always had this, according to his testimony, had this air pistol holstered, except for maybe a time when he was inside the house. I understand there is a video, but the video does not show what happened onto the porch which would have been outside the appellant's house. When the appellant went out and had a discussion or even argument with the individuals who were onto his property, crowding the street, he realized that he had the air pistol holstered, and he realized that somebody had seen it. At that point in time, he turned and went back inside. What really is incredible, if you read the testimony that the alleged victims were arguing that, alleging that they were threatened with a gun that they believed was real, a second argument occurred. Okay, that a woman actually went up to the appellant's door and confronted the appellant afterwards and argued with him about what had occurred, which to me is incredible. That if the allegation is that he had a gun that they believe was a real firearm, it doesn't make any sense, or it doesn't stand the reason that somebody would go back to confront him at his door and continue an argument with him.
Excuse me, Mr. Hall. Before you get to the meat of your legal argument, can I ask you a question? I was, of course, looking at the journal entry that you attached and the sentence that your client received. Did he get a stay of execution of that sentence?
I don't believe so, Your Honor. No, he did not.
So by my calculations, if they're correct, he would have completed his sentence already. Is that correct?
Well, no, he served his time, Your Honor. This would just be a matter of reversing the conviction and getting it off of his record, Your Honors. Can
you tell me then why this appeal wouldn't be moot since he already served his time?
Well, the sentence served is only part of it. There's also a record of conviction, and this record was aggravated menacing, which is a very serious charge to have on your record. Yeah, I would say that for purposes of employment, for purposes of maybe going to school, college, or even any type of an encounter with law enforcement, when that comes up on the officer's computer, aggravated menacing, that raises the level of the encounter and makes a much more serious situation, because at that point the officer's concerned that he's encountering a person who is a possibly dangerous individual. So there's also a matter of the safety for the appellant to get this conviction reversed, okay? So he doesn't have to show up on his record, Your Honor.
Thank you for addressing that.
You're welcome, Your Honor. Now, in this case, the video appellant said things that were obviously regrettable. Okay, and there's no doubt about it. But those things that you have to understand the situation, that he was frustrated and he was scared, and that part of this incident was not handled probably in the best manner, saying some of the things that he had done. But those things that's not what he's charged with. Okay, he's charged with actually threatening or brandishing a firearm, which would be the air pistol that he had, a non-lethal. He characterized it as a non-lethal item for self-defense. I believe in this case, the jury's conviction is against the sufficiency of manifest weight of the evidence. I think the jury just lost its way because I think as soon as they heard that there was a firearm involved, whether it's holstered, I think at that point in time that the jury believed that in and of itself, having a holstered firearm would constitute aggravated menacing rather than actually brandishing it. And what I think they got lost also, Your Honors, the fact that if this happened, it's incredulous that somebody would go back and confront him at his door rather than wait for the police to get there when he's alleged to have a firearm. That their testimony was that they believed it was real. So that makes no sense. So I think the jury got lost there. I think that's certainly reasonable doubt that any of this occurred, that he brandished any type of weapon, because it seems to be that nobody would have went back to confront him at his own house, at his own door. Because if that's the case, that would create a very dangerous situation if you actually believe that somebody had a firearm and were brandishing or threatening somebody with it. You certainly would not go back after they went in the house to bring them out again to continue some kind of a confrontation or argument with them, Your Honors. I believe the jury lost their way in this case, and I think his conviction should be, there's certainly reasonable doubt, I believe, in this case. I think the video was inconclusive. It showed what happened inside the home, but what he did inside the home was not, I don't believe that was a violation of any statute or law. He's allowed to be within his home. I think outside the home was inconclusive, and I think that's reasonable doubt, Your Honors. Thank you.
All right. Any questions, Judge Hensel?
No, thanks.
Judge Callahan, any follow-up questions? All right, you'll have your full 5 minutes then for rebuttal, Attorney Hall.
Thank you.
Thank you for your argument.
You're
All right,
welcome.
counsel, you'll have 15 minutes if you want to proceed. Go ahead.
Thank you. May it please the court, my name is Megan Philbin, and I represent the appellee, the state of Ohio, in this appeal. So Mr. Wilk was charged with aggravated menacing under Ohio Revised Code 2903.21a. And Mr. Wilk did knowingly cause another to believe he would cause serious physical harm to the person when he had threatened a group of 14 to 16-year-old girls with a gun. The girls were merely parked on the street outside of Mr. Wilk's home when they exited their vehicle onto the street, and Mr. Wilk yelled at them from his porch to move their car and pointed this firearm at them. Excuse me. When the victim, and her initials are MM, walked to the sidewalk, Mr. Wilk had brandished what appeared to all of the girls to be a firearm. The victim stated that he had pointed this firearm at her and she was afraid for her life. She had never been in a circumstance like this before. Later, it was found out through police investigation that this firearm was actually like an air pistol BB gun with the orange tip removed from the gun. So it was at the time indistinguishable by the girls whether or not it was a real firearm or not, and they believed it to be real. And Mr. Wilk was found guilty of that aggravated menacing by jury on October 29th of 2021. So Mr. Wilk has filed this appeal arguing that there was insufficient evidence to support the jury verdict and that the conviction was against the manifest weight of the evidence. So the standards to both of those. So for insufficient evidence, it's whether the prosecution has met its burden of production by presenting sufficient evidence to sustain a conviction. So were the essential elements of aggravated menacing proven beyond a reasonable doubt? And for manifest weight, the standards to review the entire record, consider the credibility of the witnesses, and resolve any conflicts of evidence. So the ultimate question is, did the jury lose their way and create a manifest miscarriage of justice? So here we've got several witnesses who had testified at the jury trial, and these are young girls. They're not women, they're young girls, testified to the incident. The victim had testified that Mr. Wilk yelled at her, removed his gun from his holster at some point during this incident and pointed it at her. She had asked him, "Is this a gun?" And he said, "Yes." She was scared. She thought Mr. Wilk was going to shoot her. She thought that she may die. Two other witnesses also testified, and these witnesses also were two young girls. And they too saw this weapon, and they saw Mr. Wilk point it at MM, the victim. So they were afraid he was going to shoot MM. They also didn't know if they would be shot as well. And some of the girls had testified that they ran away from the incident because they were afraid. So I think it's important also to note that all of the girls testified that no one was on Mr. Wilk's property. In fact, they were in the street when the incident first started. And then one of the girls, MM, had moved to the sidewalk, and that was as far as she got. She never went onto Mr. Wilk's property.
Where did the second confrontation occur that Attorney Hall mentioned?
Yes, so I'm glad that you've brought that up because, excuse me, this second confrontation. So after Mr. Wilk had this incident with the young girls, all the girls fled and went to one of their friends' homes. And when they went to that home, there was an adult there. One of the parents of one of these girls was there. And after the girls told them what had happened, the parent of one of the girls went back to the home to confront him. It was not one of the victims, not one of the original girls. It was a concerned parent had gone back to the home. So once the police did arrive, they did talk with Mr. Wilk, and he did admit to having that gun, or it was an airsoft pistol, but he did admit to having it in his hand at some point to the police as well.
Did he have the gun in his hand when there was some comment that he made, "Do you think I'm playing around?" Or do you recall that part of the transcript where there was testimony that he said, "Do you think I'm playing?" I think he said.
Yes,
was the gun in his hand at that time?
I'm not going to misstate the record because I don't recall it. I'm sorry. But there is not only the transcript of the hearing, but also there is the State's Exhibit 2, which was admitted in evidence, does have the indoor surveillance of the incident, and I believe that it's on there. So that's State's Exhibit 2.
So there's audio on State's Exhibit 2 as well as video. There's audio.
Yes, that's correct. There's audio from inside the home. So it's an internal view of Mr. Wilk. There's no, my understanding is there's no view outside of the home to the girls outside.
Can you tell me a couple of things? Is it one car that parked out front of his home or more than one? There seems to be a discrepancy between the briefs.
There were two cars parked outside, is my understanding. My understanding was that there were 4 young girls that were outside, and some of them had already left by the time that the whole incident with Mr. Wilk had started.
And I know the statement, was it agreed that the cars were legally parked there on West Union Street?
Well, I know it's the state's position that they were legally parked there. They were not, they were on the opposite side of the street in a parking spot. So it wasn't on Mr. Wilk's side of the street. So it's state's position they were legally parked there. I don't think there was really a dispute that they were permitted to be on that part of the street.
And the place where they were heading, does the record reflect that they were heading to a location that was on Mr. Wilk's side of the street, or were they heading someplace else from their parked vehicles?
I am not certain that the home they were going to was on Mr. Wilk's side of the street. I do know that they were going to a home on that street of one of the girls. So I'm not certain which side of the street that was on, though.
Okay, thanks.
All right, so comparing what was provided by the state, so which we had the testimony of these young girls, but we also have the video surveillance that was provided by Mr. Wilk to the state, and the state actually did use that in our case. That surveillance did corroborate what the victims and the witnesses' version of the events were. But comparing that to Mr. Wilk's testimony at trial, the state's position, he was not a credible, rational witness. He had described something along the lines of like a zombie apocalypse almost, that his home was being attacked. He believed that this young group of girls was attacking his home, going through the thistles in his garden, I believe is what he described. Though in his own surveillance video, the only issue that he was verbally expressing to these girls was that they were parked across the street from him. Had they been climbing through his garden, going onto his property, I'm certain that it would have been something he would verbally have expressed, but he did not express that on the video. And he had only repeatedly told them to move his car, amongst other slurs and things that he did say to them. So his testimony from the state's position was very bizarre. What he did discuss in his manner of testifying was also bizarre and inconsistent at times. So it's the state's position that we've provided ample evidence that Mr. Wilk did commit aggravated menacing against and the victim through witness testimony and the evidence that was presented at trial. There was sufficient evidence of this offense. Further, the state's witnesses and evidence were highly credible when compared to Mr. Wilk's testimony. And the jury did not lose its way in finding Mr. Wilk guilty of aggravated menacing. So I'd ask this court to overrule both assignments of error in this appeal. Thank you.
All right, thank you. Judge Hensel or Judge Callahan, any further questions? Nor do I. So thank you very much, Attorney Philbin, for your argument.
Thank you.
Attorney Hall, you have 5 minutes.
Yes, thank you, Your Honors. I think there's some things that are not in dispute between the appellant's testimony and the testimony of the alleged victims in this case. It's one, that there was an airsoft pistol that's undisputed, and there was also a holster, which was recovered by the police. So apparently, either the holster, I believe the holster was provided by Mr. Wilk to the police, but his testimony was that he was wearing the holster at the time, and the airsoft pistol or air pistol was in that holster. Also, once again, I'd like to draw the court's attention to how incredulous it sounds that the girls ran away and went to a house of one of the parents of one of the girls and spoke with somebody there, and apparently about an airsoft gun or what they believe to be a weapon. If that's the case, it's incredible that somebody would then leave that house and go to Mr. Wilk's house and confront him and bring him out while he's inside of his house now after this incident had ended. So apparently, it seems to me that the concerned parent didn't believe that there was a threat, that threat existed, or they would not have gone there to confront Mr. Wilk if he had a firearm, was threatening these girls. Do we know
who called the police? Was it the concerned parent who notified the police about the incident?
I'm not sure, Your Honor, but when they got there, Mr. Wilk cooperated. He turned over the air pistol to the police along with the holster, which I think the holster corroborates the fact that he did have a holster, and that supports his argument that during the period of time that he was outside the house, he had the air pistol holstered. I would ask once again, I direct the court, I think that there's some, based upon the video, the state's own evidence that was only showed the inside or interior of Mr. Wilk's house. It didn't show the outside. I think there's certainly reasonable doubt as far as whether he brandished that weapon outside the home. I think another thing the jury may have gotten hung up on, or certainly prejudiced Mr. Wilk, was some of his comments and the words he used that were directed at these girls. I think that may have inflamed the passions of the jury in this case, and them basically rendering a guilty verdict based upon some of the comments and words that he used, which were once again regrettable, Your Honors, in this case. Certainly that those comments were not helpful to Mr. Wilk's case in this trial. Thank you.
All right, questions I should ask before we, no? All right, thank you very much, Attorney Hall, as well. We'll take the matter under advisement, issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it is released. And you can also keep an eye out for the Ohio Supreme Court's website where our opinions are posted. That being said, on behalf of Judge Hensel and Judge Callahan, I want to thank you for appearing today by video. And looks like we've got a pretty nice day out there. So we hope you enjoy your day.
You too, Your Honors. Thank you. And take care.